Made, Your Lordship. So this is an application under Section 220, Article 226 of the Constitution of India, read with 227, invoking Your Lordship's superintendent jurisdiction in so far as a challenge to an order of detention that was passed by the Judicial Magistrate First Class UPA. My endeavor today would be to establish that that order of detention was an illegal order, and therefore the consequential reliefs that I am claiming for.
He's seeking compensation.
Compensation as well as a declaration that the order was illegal, detention order was illegal, because the humiliation that I have suffered and the loss of dignity needs to be restored, Your Lordship. So if I may therefore now place the facts as to leading to the present filing of this petition, Your Lordship.
You can.
If Your Lordship will come to page 23. Just before that, if I may just speak about the background as to why this issue has happened. There was an ex-DC here called Mr. Talopotam. Now, he has been involved in a sensitive case where there has been two persons who have committed suicide. And in the suicide note, he has also implicated Talopotam, and therefore he was arrested. Now, this has been an issue of public interest and social interest. People were definitely enraged by the issue, and there were people who came to the court to object as to what was happening. Now, in that scenario, this entire incident has happened. Now, if Your Lordship will come to page 23, the petitioner's name is Tesi Puru. Now, Tesi Puru, he was undergoing a trial in Papu Hills PS case number 10 of 23. This is an order of 37/2025. I'm just placing these orders for Your Lordships to appreciate that on that particular day of 37/2025, an order was passed whereby the case was fixed on 29/10/2025 for consideration of the charges. So that is how on 29/10/2025, the petitioner was before the Honorable CJM Court, Judicial Magistrate First Class Court. Now, if Your Lordship will come to page 24, 24 is the impugned order.
2910.
29/10/2025. I'm just reading it slowly. On 27/1/2025, when the accused person, Talopotam, was produced by the Nirjuli police, a huge crowd had gathered outside the court premises. The crowd, which allegedly comprised of family members of the victim and other unknown people, interfered with the regular court proceeding and also threw stone and broke a glass pane of the court building. Tesi Puru was seen instigating the crowd. He has also admitted that he was protesting on the day and was present when the accused Talopotam was produced. As such, Tesi Puru is detained. OC PS Doimuk is directed to take Tesi Puru and to process him as per law. The OC PS Doimuk is directed to ascertain his involvement into the matter, into the incident. He is also directed to ascertain the veracity of the video footage. Furnish a copy of the OC PS Doimuk for information and compliance. Now, therefore, one thing that is evidently clear from this order is the learned magistrate on that day was acting without there being any FIR or complaint, but merely on a presumption, I would say, to ascertain that his involvement, because he himself says that to ascertain his involvement in the incident. So therefore, it could be seen that there were no materials conspicuously available on record to indicate that the petitioner was involved in any offense, and that to an offense of 2710. That is very important. When the offense occurred, alleged offense occurred, 2710, and his involvement therein. Now, thereafter, if I would take Your Lordship.
Okay, and it was wrong. It was on 2710, right?
2710 was the date of incident.
Okay, it was, I think, wrongly typed here. 27-1.
Oh,
okay. No problem. That's not a problem.
yeah. Oh,
But
yes, Your
I'll
Lordship.
just
Yes. It's
cross-checking it.
Yeah,
2710.
2710 is the correct date, Lordship. And on 2910, I was there pursuant to a different case wherein I was summoned for consideration of charges. So therefore, I was there in that court on that day to appear in a different case. Now, if Your Lordship will come to page 25, Annexure 3. One thing that I would like to refer is at the very top, Lordship will see the date and time of the FIR, 29/10/2025, and the timing is 12:30 hours. As we've seen that. And at serial number 3, B, small b, Information received at the PS. Date is 29/10/2025. Time is 12:30 hours. And the next line, Lordship will see, entry number 005. Date and time 29/10/2025. 14:07 hours. The FIR came after, and the FIR was registered in the police station, or in fact, the registration took place later on, but the entry was at 14:07. Now, if your Lordship will see, even at the top portion, when it was seen, 30/10/2025. Cognizance was taken on 30/10. That is 1 day after my detention order. So therefore, on that particular day, and if I may just take your Lordships to the FIR also at page 28, I'm not a name accused here, page 28.
Yeah.
With
So,
reference,
the FIR was lodged subsequent to the detention.
subsequent to detention.
Anyway, sometimes it can happen, as you know.
No, I know. That is true.
uh,
What I am trying to make your Lordships to appreciate, bring your Lordships to appreciate is that on the day at the time when the learned magistrate had passed his order of detention, there was no FIR or complaint before him. From here, he could have taken cognizance that an offense has taken place. There are non-bailable sections, and probably section 35 of the BNSS is also not required to be complied with. Offenses where punishments are more than 7 years. It was not. Those materials were never before him. That is my endeavor, Lordship, why I am placing this FIR and this particular date. Now, the FIR, Lordship, I will not go through the FIR. The FIR says more than 100 people had done picketing activities and vandalism in the court, and 1 glass pane was broken. Now, if your Lordship will come to page 34, is the forwarding. Oh, before that, if I may just
Page 31,
page
not 31.
page 32. Page 32 is the arrest memo.
30.
Arrest memo, I'll just show one, serial number 7. Page 32. Serial number 7. Date and time of arrest, 29/10/2025 at 8 p.m. to 200 hours, 8 p.m. Now, if your Lordship will come to page 34, which is the forwarding. Pursuant to the detention order, I was arrested on that day on the basis of the FIR at 8 p.m. Now, on 30/10/2025, I was produced before the magistrate, the learned magistrate, and this is the forwarding. Now, in the forwarding, I would just like to draw your Lordship's attention to the reason for arrest at page 35. Page 35, reason for arrest. The accused was arrested because on 29/10/2025, in the forenoon, the Honorable Court JMFC UPIA has detained Sri Tesipuru during the court proceedings of his earlier Papu Hills PS case, so and so, on the charges of instigating the crowd of the protest rally against the alleged accused Sri Talopotam on 27/10/2025 during production in connection with Nirjuli PS case number 92 of 2005. So therefore, it also been indicated in this forwarding that it was pursuant to that order of detention that was passed by the JMC, the police had to arrest him. Now, if the sections that have been added to this case, if Lordship peruse the sections, all the sections are otherwise bailable, barring section 132 of the BNS, wherein also the punishment was not above 7 years. The punishment that it carries is not above 7 years. Therefore, had it been a case 132, section 132, which also finds reference in the order of bail that was given to me on that particular day by the learned JMFC, where he indicates that the other sections are bailable, only 132 is non-bailable. Now at page 37, on 30/10/2025, this is an order passed by the same judicial magistrate. May I just read that order?
Yes.
30/10/2025. Accused person, namely Sri Techipuru, 40 years, is produced before me by the IO of the case. Seen and heard the accused person. Accused person stated that he can engage counsel of his own. Peruse forwarding, arrest memo, come checklist, accused challan, medical fitness report. Medical documents state that the accused person is clinically unfit to be kept in custody. Peruse the FIR, wherein it is stated that a written complaint is received on 29/10/2025 from advocate Nabam Rama to the effect that on 27/10/2025, more than 100 persons gathered in an unlawful assembly in the CGM JNFC Court Complex UPR in connection with Nirjuli PS case number 92/2005, and the mob forcefully entered the court campus and attempted to storm the courtroom during ongoing judicial proceedings, and thereafter pelted stones at the court building, causing damage to window glasses and obstructing court functioning. Hence the case. Seen that the IO has prayed to remand the accused person, Sri Teshi Puru, to judicial custody, as his custodial interrogation has been completed and he is no longer required for the purpose of investigation. The IO also stated that the grounds of arrest was conveyed to the brother of the accused person, Sri S. Tana Nado Tara, and a copy of the arrest memo is also supplied to him. All the offenses charged with against the accused person are bailable in nature, except for the offense under section 132 of the BNS, which deals with preventing public servant from conducting or performing their duties. Considering the submission made by the IO that the accused person is no longer required for the purpose of investigation and the fact that the accused is not clinically fit, it is to be kept in custody. I am not inclined to allow the prayer of the IO for remanding the accused person to judicial custody, and therefore the alleged accused is released on bail. Interestingly, on that day, we even didn't file a bail application.
Yeah, it was given suo moto.
It was given suo moto on the ground that further custody is not required. In fact, then the police also in the forwarding have stated that they do not require any further custody. So what therefore transpires from the entire episode was that on that particular day of 29, when I appeared before the learned JMFC for a different matter, I was charged by the learned JMFC by stating that were you present on that day? I submitted that yes, I was present. But I never stated that I was in the act of vandalism.
Yeah.
So therefore, there could not have been any occasions that I could have been detained. And moreover, what is the power of the arrest by a magistrate? For that, Lordship knows section 41 of the BNS. If I may just place that.
Now 41.
Yes.
I'll need both.
Earlier it was 44, now 41. BNSS.
Better to have both actually. Later you can also give me the CRPC. Now it is 41.
Yeah, there was no change, Your Lordship.
Yes. The contents are same.
Contents
Section
is
is
same,
different.
only the section has changed. From
Section is
44 it became 41.
Action is different.
Arrest by magistrate. She was got that.
Yes. I know that if the offense is committed in his
Lordship
presence-
always-
No, it's okay. We are all
Just
learning
for
all
my
the
anxiety,
time.
I'm placing it.
No,
for
no,
Lordship.
we are all learning all the time. Absolutely. Please, thank you.
Obliged.
So, arrest by magistrate.
Yes, Lordship. Section 41, arrest by magistrate. When any offense is committed in the presence of a magistrate, whether executive or judicial, within his local jurisdiction, he may himself arrest or order any person to arrest the offender, and may thereupon, subject to the provisions herein contained as to bail, commit the offender to custody. So therefore, the condition precedent to exercise section 41 would be the occurrence of a crime, a cognizable offense, in his presence. Just to give an example, someone comes in the court and he starts therein inside the court, he starts behaving in a manner which is not befitting a person, and there is an occurrence of a crime, like he assaulted the witness. Therein, at that point, the magistrate definitely has the power to take him into custody,
Yes.
to detain him. But herein is a
Arrest
case,
him. Actually. Yes.
because
And-
arrest, before detention, arrest will have to come.
Yeah, I mean, it's-
Yes, because first is to put him under arrest and then to hold him in detention. So arrest is followed by detention. So in my view of the matter, therefore, on that particular day of 27, the occurrence had occurred, the situation has occurred. Now, on 29, there was no offense been presented or been unfolded on that day. So he could not have taken recourse to section 41. And if section 41 is not to his aid, then there is no other statutory backing based on which he could have detained. Another aspect of the matter is there was no FIR in front of him, no complaint in front of him, based on which the learned magistrate could have acted.
no, in a case, classic case where 41 would be attracted, then initially they may not be an FIR. The offense is committed, as you gave the example.
Yes, Lordship.
That's not an issue.
Yes, Lordship.
The offense is committed in your presence. You are a magistrate. And
Yes, yes.
you arrest a person. And then, of course, something else, GD entry will be there.
Correct, Lordship. Correct.
And then maybe the FIR can.
Correct. But then it,
But the detention has to follow the arrest.
yes, but the fact remains,
So
the
those things
offense
have to
has
be
to,
examined.
the offense has to occur
Yes.
in
yeah.
front of
Yeah,
one's eye.
because the foundational facts of invoking section 41 will have to be there.
Exactly. So that is why I say.
That is commission of an offense before a magistrate.
Yes,
right?
Lordship. And that is why I say, therefore, this order of detention, maybe for 24 hours, but then it's a infringement of my personal liberty as guaranteed under the Constitution.
An aware citizen will be aggrieved if it is
Yes,
not according to law. Even for an hour, he will be aggrieved.
Yes, Lordship. And that is why we have got.
People are
As
unable
on
to-
date, Lordship, today the notice can be.
Yes, notice can be issued, and then I'll just narrate a few facts for subsequent court.
Yes.
Let them file their replies.
Yes, ma'am.
Responded. You already appearing. So,
Yes.
yeah, so you can text it. The learned. Should I dictate? The petitioner, Mr. Sharma.
Yes,
Mr. Sharma, learned counsel. For the writ petitioner who has invoked the jurisdiction under the Constitution of India with the grievance that he was wrongfully detained and arrested by learned JMFC Papum Parin on 28.
They have UPIA, I think.
You-
This is how it designates.
Just help me with the date. On 29/10.
Yes, Lordship.
On 29/10/2025, which was subsequently followed by registration of the case. In a nutshell, the learned counsel contends that the grounds for invoking the powers of arrest by the magistrate were lacking, and due to such illegal detention followed by arrest, though the petitioner was subsequently granted bail by the learned JMFC, but he is ventilating his grievances for this court regarding violation of constitutional rights and seeking a declaration for the detention/arrest to be declared illegal, and also seeking compensation under public law under Article 21 of the Constitution of India,
And the Supreme Court judgments are there in that.
and the settled law governing the field. Four respondents have been implemented and one pro forma respondent. You are accepting notice, learned counsel? You
My lord,
are
I'll be appearing for one,
one,
Chief Secretary. The rest, my
Chief Secretary. You are Mr. And we have.
N. Ratan,
Yes,
Additional Advocate General.
Advocate General, learned, accepts, appears on behalf of respondent number one. And
I'm El Hage Losif, additional public prosecutor.
Yes.
I'm appearing for 2 to 4 Losif,
Okay.
2, 3 and 4.
prosecutor, you'll be appearing. Learned, and learned additional people. Represents respond number 2, 3 and 4. The
Oh, five.
petitioner side 2, 3 and 4. The petitioner side shall furnish copies to the respective learned respondent councils. This pro forma respondent, you want
Respondent
to
number
issue a
5.
notice?
Yes, Lordship.
Issue notice upon the pro forma respondent. I feel, the subject to what you say, that after you file any reply, thereafter we can call for the case diary.
Yes.
Isn't it? Otherwise it will remain stuck.
Yes, boss.
Investigation is going on perhaps. Oh. This is the matter on
A date. Lordship,
After-
kindly give a date.
yes.
4 weeks Losif.
after 4
Okay.
weeks. After 4 weeks.
My request is only to give a date, Lordship. Now I'm our station council.
After 4 weeks, on so and so date for service report with regard to pro forma respondent and affidavit in opposition with regard to the state respondents.
11.
You can suggest both of you date.
11th.
11 December.
Yes, Lordship.
Hmm?
11th.
4 weeks, that will be beyond 4 weeks. Okay, almost marginal. 11,
11 December.
11, 12.
Yes, Your Lordship. It's fine.
All right.
Oblige, Your Lordship.
Item number 2,